What is up, everybody? So yesterday on February the 7th, 2025, Kathleen Zellner filed a petition for review with the Supreme Court of the state of Wisconsin. I will link part 1 of this video in the description below. This is part 2, and we're going to jump in with the argument. We're on page number 11. Whether the appellate court improperly imposed a burden on Stephen Avery to conclusively prove the Denny motive element in order to satisfy the materiality prong of the State versus Edmonds. Standard of review. The state's highest court will not disturb a circuit court's decision to admit or exclude evidence unless the circuit court erroneously exercised its discretion. A circuit court erroneously exercises its discretion if it applies an improper legal standard or makes a decision not responsibly supported by the facts of the state, imposing improper standard on the newly discovered evidence. Both the Circuit Court and Court of Appeals imposed an improper standard in evaluating Stephen Avery's newly discovered evidence. The Court of Appeals found the Circuit Court properly recognized Stephen Avery's newly discovered evidence was not independent from Stephen Avery's attempt to meet Denny and addressed whether the evidence was material within the confines of his third-party perpetrator argument. Both lower courts improperly merged two standards into one in order to deny Stephen Avery's newly discovered evidence. The merging of the two different standards, that in Edmonds and that in Denny, allowed the lower court to base the materiality of Stephen Avery's evidence on proving that Bobby had a sexual motive to kill Teresa Halbach, and also proved beyond a reasonable doubt that he alone made every single pornographic search on the Dassey computer. The lower court's analyst completely ignores that the Thomas Sawinski evidence is independently material for numerous other reasons besides proving that there is a third-party suspect for the murder of Teresa Halbach. The Court of Appeals avoided addressing this independently material evidence by inaccurately claiming Stephen Avery analyzed the Thomas Sawinski evidence within the context of a third-party perpetrator defense. The Court of Appeals pointed out in paragraph 4 of its opinion from July 28th that Stephen Avery argued that Thomas Sawinski's new evidence is material because it shows that the RAV4 did leave the Avery property and was in possession of a third party, not Stephen Avery, thereby debunking the state's theory that Stephen Avery had exclusive possession of the vehicle and the forensic evidence contained within it, and that he keeps the RAV4 on the Avery property by a crusher so he could crush it immediately. The prosecutor, in his closing argument, told the jury that only one person was responsible for the crime, and that person was Stephen Avery. I believe that person was Ken Kratz, and I've actually had this conversation with Ken Kratz, and I got explained from him and numerous other people why he had to say that, because in the next trial he also convicted Brendan Dassey of that, which makes the law in Wisconsin completely hypocritical. For him to say that one person was responsible for the murder of Teresa Halbach, and that murder was Stephen Avery, and then have to go give a complete different defense because that's what the law requires in Wisconsin, even though he had stated previously that one person was responsible. Now he goes and gives a complete other defense in a separate trial and also convicts Brendan Dassey for the same murder, even though in the trial previous it was one person. I get why they have to do. I don't get why they have to do it. It makes absolutely no sense. But that is the way they have to do it in Wisconsin, which makes that particular law bananas. Stephen Avery argued the evidence of a third party's possession of Teresa Halbach's vehicle is additionally material because it shows that someone other than Stephen Avery had possession of the forensic evidence used to convict Stephen Avery. The vehicle, by virtue of having all of the relevant forensic evidence in it, including Teresa Halbach's blood, was the most important piece of evidence in the case. In his closing, the prosecutor stated, because the discovery of the RAV4, the discovery of Teresa Halbach's vehicle, changed the course of not only this case, but the clues and secrets found in the vehicle changed the lives of everybody in this room. The prosecutor emphasized to the jury that nobody had access to the car and no one was going to tamper with the SUV after it was located. However, the Thomas Sawinski evidence established that Bobby Dassey, the state's primary witness, had access to and the ability to tamper with the vehicle before it was located. Stephen Avery was entitled to have presented this critical fact to a jury, and not being allowed to do so deprived him of his constitutional right to present a complete defense. Despite police searches preceding the discovery of Teresa Halbach's vehicle, Teresa Halbach's electronic devices and key were not found until after Teresa Halbach's vehicle was found. The only reasonable inference is that all of the items remained in Teresa Halbach's vehicle, and then they were moved by the third party who had possession of her vehicle and planted it and around Stephen Avery's residence. If a third party had possession of Teresa Halbach's vehicle, numerous areas of reasonable doubt arise, such as the forensic evidence in the vehicle was tampered with by the third party having control of it before it was discovered by law enforcement on the Avery property. This would have created reasonable doubt in the jurors' minds, particularly since the state's primary eyewitness was the one in possession of the vehicle. Thus, Stephen Avery's new evidence also presents an alternative theory for the source of the forensic evidence used against Stephen Avery. Importantly, Stephen Avery also argued that Thomas Sawinski evidence impeaches the credibility of Bobby Dassey's trial testimony, where he established an alibi for himself while implicating Stephen Avery in the murder. In fact, Stephen Avery spent numerous pages on his third motion explaining the impeachment value of Stephen Avery's new evidence. Bobby Dassey testified that he left the property while Teresa Halbach and her vehicle remained on the property with Stephen Avery. This crucial testimony allowed the state to claim it was Stephen Avery, not Bobby Dassey, who murdered Teresa Halbach and concealed her vehicle on the property. During its closing argument, the state emphasized the importance of Bobby Dassey's testimony, vouching for his credibility. Again, an eyewitness without any bias. It is an individual that deserves to be given a lot of credit. If this is true, any of this is true, of course, Bobby Dassey had a ton of bias. With the new Thomas Sawinski evidence, the state could not possibly have presented an unimpeached Bobby Dassey to establish Teresa Halbach had never left the property in her vehicle and that she was last seen walking towards Stephen Avery's trailer. Its critical eyewitness link to obtaining Stephen Avery's conviction. Bobby was the only witness whose testimony the jury requested to read or hear a transcript of. Clearly, by Bobby possessing the vehicle, there is a reasonable likelihood it would have affected the judgment of the jury, in that Bobby Dassey would have emerged as much more likely suspect in Teresa Halbach's murder than his recently released, wrongfully convicted uncle. Contrary to their 1985 case, contrary to the state's representations to the jury, Bobby was biased and deserved no credit for his fabricated testimony. In regard to a motion for a new trial, a reasonable doubt to a defendant's guilt has been found to exist when the credibility of a witness critical to the state's case is completely called into question by newly discovered evidence. A new trial is required if the false testimony could, in any reasonable likelihood, have affected the judgment of the jury. Stephen Avery presents a stronger case about the materiality of his newly discovered evidence because his evidence shows that Bobby Dassey committed perjury in his trial testimony, and it taints all of the forensic evidence against Stephen Avery, which resulted in his conviction. Prior to the Thomas Sawinski evidence coming to light, the Court of Appeals assessed Bobby Dassey's testimony. However, in Stephen Avery's third motion, he brought forth newly discovered evidence that does both. It completely impeaches Bobby's testimony while casting doubt on all of the forensic evidence used against Stephen Avery. Thus, Stephen Avery has shown how his evidence is highly material, independent of establishing Bobby Dassey as a third-party suspect. Besides requiring Edmonds' materiality to be solely based on being able to meet the Denny requirements, the Court of Appeals erroneously found Stephen Avery did not offer any analysis that explained why his newly discovered evidence was not cumulative outside of a third-party perpetrator defense. However, even if there were multiple examples of Bobby's impeachment for purposes of a Brady claim, the court is not to view each piece of the suppressed evidence in isolation. Instead, the court is required to assess the cumulative impact of the suppressed evidence to determine its materiality. The continual effort to move the goalpost to thwart Stephen Avery's post-conviction efforts by employing the use of per curiam opinions which blatantly violate his constitutional rights to present a complete defense cannot and should not be condoned. Further, contrary to the Court of Appeals' assertion that Stephen Avery did not offer any analysis that explained why his newly discovered evidence created a reasonable probability of a different outcome on a retrial that was independent from Stephen Avery's attempt to meet Denny, and addressed whether the evidence was material with the confines of his third-party perpetrator argument. In Stephen Avery's third motion and briefs on appeal, thoroughly analyze why the Thomas Sawinski evidence is independently material and would have created a probability of a different outcome on retrial. This is where I'm going to end part 2. I'll be right back with part 3. What do you think of everything so far? Let me know.